So let's start with the good one. I mean, let's start with the best decision coming out of Florida. Good segue. The Court of Appeals is overturning or has overturned a lower court decision, which I posted a snippet of this judgment. It would be comic if it weren't tragic. The lower court judge in his ruling, what do we call? We want to say sanctioning as in authorizing required face masks, says that there's no constitutional right to not wearing a face covering in public locations. Because somebody was contesting the face mask mandate. I forget what district it was or what county it was.
Alachua County, where Gainesville, the University of Florida, is located.
Okay, so the guy's name was Justin Green, was contesting these face mask requirements. There was the issue as to whether or not it was moot because the mandate had been lifted. Court said it wasn't moot because it could come back anytime. Bottom line, lower court says it's not a constitutional infringement. They did not apply strict scrutiny. I guess they applied intermediate scrutiny, or maybe, I don't know what's less than that, but we'll get there. Court of Appeal comes in and says, this is all wrong when there's a right to privacy constitutional question, automatically presumed unconstitutional, and you have to prove that it is constitutional, and you have to apply the criteria of strict scrutiny. And the court basically came in and said, everything this lower court said was wrong. This is fundamentally an issue of privacy. In Florida, you have a right to be let alone by the government, which I effing love. And you're going to have to explain that. So first question in all of this, the three levels of scrutiny. You have strict, intermediate. What is the lowest level of scrutiny?
Rational basis. Okay.
And so the three levels apply to what types of laws?
To any government action. So that if the government is in some manner infringing upon some protected interest, then the degree of scrutiny depends on what interest that the government is infringing upon.
Okay. And so then I guess what was the first one? I forgot the first one already, but no scrutiny, intermediate, strict scrutiny. Intermediate is for what? The more invasive it gets, the more scrutiny it's subjected to.
Exactly. And the more core protected freedom it affects. So like there's a big difference between, say, freedom to travel and freedom of religion, as an example.
Okay. I will not ask the same question I asked last week because now I know, and knowing is half the battle. Thank you very much, TRDS. Thank you. So here's the question. The right to be let alone. Is that common to states or is that unique to Florida? And explain what that is, because it blew my mind and I love the idea.
I think fundamentally it's a right that's always been there, but it hasn't always been recognized as part of the constitutional protection. So my view is the combination of the right of free speech, freedom of religion, freedom of the press, petition your government, your Fourth Amendment right against unreasonable searches and seizures, your Fifth Amendment right against your property being taken without just compensation, and the right to due process of law and equal protection of law, that those in their aggregate mean a right to be left alone and a right to dictate what you, within reason, but a right to choose your own dress. That medical Sharia law, which is what I considered mask mandates to be, were constitutionally offensive for that reason. However, in Florida, it's easier because Florida explicitly protects the right to privacy and includes within their constitution, literally the language, the right to be left alone from the government. And that's what it's not a surprise that the trial court judge in Alachua County didn't find that right or decided it didn't apply somehow, because that's one of the liberal democratic strongholds in the state of Florida. That's why it also has all these rules. Now, the appellate decision was fantastic just because some of its language, it talked about all the rats and the informers and the way that this, and used wonderful verbiage and pointed out that really simply weaponizing and deputizing the entire city and the entire county against the local populace was its own invasion of privacy, its own, because they point out this particular mask mandate could apply to you in your own home. That's how insane this particular one was. And thanks to the individual who continued to challenge it and the lawyers who continued to fight for it, they found a conscientious appellate court that recognized the law as clear, that this has to pass strict scrutiny, and it's presumptively unconstitutional under Florida law. And interestingly enough, they're citing abortion-related decisions. So where some liberal Florida Supreme Court justices have broadly expanded the meaning of the right to privacy in order to protect abortion rights, these are some smart judges who are like, well, then that sure should apply in the context of any other context. And because the liberal Florida Supreme Court had previously lectured that Florida appeals court for not giving due deference to privacy rights, they were very vigorous and very intelligent about how they went about it. And I think that it's a great decision for everybody for the future. I think it's universally applicable. They do cite several federal U.S. Supreme Court cases, but it's easier to establish that right in Florida because of the explicit language of the Constitution in Florida.
All right. And now, Robert, I said I'd ask after you finished. Are you able to close the blinds? It might eliminate some of the
ambient light.
Yeah, well, some of the flickering. It's going. Yeah, if you could do that, that might be even better. And now, just so everybody knows what Robert's talking about, I skipped that paragraph. They did use verbiage like diktats, which I didn't know what it meant. D-I-K-T-A-T. So the court was immediately offended off the bat. And they were saying, that the right to privacy is enshrined in the Constitution effectively, that everyone has the right to be let alone. And they said it wasn't just the egregiousness of the mask mandate itself. The government was literally putting out, what do they call them? Not advertisements, but publicité. What do they call, for goodness sake? Ads.
Brochures and pamphlets.
Brochures saying, here's a number you can call in if you see people breaking the law, breaking the mask mandate. And they're like, that's great. This is one thing I've been observing. It's actually the most depressing thing is I've never been able to fully appreciate how a government or how anybody can pit citizens against citizens. I'm seeing it now in real time, and it's very depressing because you get people who are so nervous. Going back to the Mad Max intro, people literally think Mad Max he's literally risking people's lives by hosting a outdoor rally of 20 people. You've got people who believe that. And when you've got people believing every violation of a mask mandate is an existential threat to their health and existence, you can get people to do pretty much anything. And it goes back to Nietzsche, who says if you can get people to believe absurdities, you can get them to commit atrocities. So the judge was like, yeah, this is not only a ridiculous mandate, the government is getting people to rat on their neighbors, snitch on their neighbors. And they were really, it was great. The question is this, what district appellate court was that?
So it's a Florida state appellate court. So its ruling applies throughout the state of Florida at this point.
Okay, I'm sorry, it's not a federal court for that.
Court.
Say that again?
Unless the Florida Supreme Court were to reverse it, which I don't anticipate.
Okay. And it's great. You think in the states, do other states get to use this as some form of precedent, or did you?
Oh, yes. Every litigant should look at it because it's got favorable language and it's got analogous principles that, in my view, are universally applicable in every state. It's not as strong in other states as it is in Florida, but that doesn't limit the utility of this precedent for other jurisdictions to consider as persuasive argument in its favor.
All right, amazing. If anybody has any questions on this, get them in now. I think that's pretty much it. Oh, that was my question strategically. I think there's been a couple of decisions now that are coming out which are favorable, but they're all coming on the tail end of mandates and restrictions. So the question is this. Some people are hypothesizing that it's going to be easier for the courts now to come down with these decisions that are going to slap the hand of the government because the mandates expire in a day or two, so there's no harm, no foul type thing, but they get to set the good precedent. Is that the case, or is the next time there's another emergency, they're going to say it's just different, so this doesn't apply?
I think every argument is going to be helpful because any case that deters and discourages the future use of these rules is going to be helpful. Absolutely. So just because they waited until the ship had sailed to finally do something about this doesn't make it without impact or consequence for future governmental powers, because these will become the governing, deciding cases for the future. That's why I've encouraged people to continue to march on with these cases, even when they may appear to be moot. And this court made the point that they keep coming back over and over again with emergency declarations of this, that, or the other. So we're not going to consider anything moot in this context. And so, this was an over a year-long emergency order by the local politicians. It was extraordinary how this works. But similarly is almost as insane as the Kentucky governor, who even after the legislature strips him of his powers, he ignores their stripping of his powers and says he still has them anyway, and has issued one crazy rule after the other. And we had a great trial court ruling from Boone County in Kentucky with a Stickman-like decision, because it was one that went all the way through trial. And this was a judge who had previously said that these rules were unconstitutional. The Kentucky Supreme Court had set it aside, saying the state legislature gave the governor that amount of power. So the legislature came back and said, no, we didn't mean to give him that amount of power, and took it away from him. The governor said, screw you, I'm going to pretend I still have the power. That's how power hungry these people are. I mean, the guy's guaranteed he's got no future left in Kentucky. He just doesn't know it yet. So they went back to a full trial in front of this judge, and this judge and two experts testified. So it was like Stickman. Both sides got to present substantial evidence. And once again, when the state is put to trial, they cannot produce hardly any evidence in support of their provisions, of these mask mandates or lockdown rules or capacity restrictions or vaccinations or anything else. They just can't find the evidence somehow when it actually has to meet the evidentiary standard of a trial. Whereas two of the top experts in the country testified for the plaintiffs against the state, including one of the top industrial health experts, who what the court had some great evidentiary findings that people can use for future cases, where he said, based on his review, and this is a guy who's testified in over 100 cases, been a certified expert without question, hesitation, reservation, or doubt. And he said neither the mask mandate nor the social distancing rules had any evidentiary foundation whatsoever as being good for public health. And then, in fact, there was substantial evidence it was more detrimental than beneficial to public health, if that was the only metric used. And based on that, the judge struck down the rules, said these rules just can't conform to any, they don't even meet rational basis. It was like Judge Stickman's decision. He's like, even the lowest possible standard, they can't even meet when given the opportunity to present expert evidence. They can't find it. They can't amount to any of it. So another great ruling from another Southern court that hopefully will be helpful. And it shows the tide continues to turn as people become more awakened.
Yeah, the tide turns when sort of when people are out of the pool already. I'm trying to think of a good analogy, but it's like, now we're at the tail end of it. People are getting vaccinated. The virus itself might be, tailing out, but now people get brave. But we needed to get here in order to get here. I just want to read. Ziggy Shrugged said, "I am in Volusia County. I'm pronouncing it wrong. Even after the ruling, the Volusia County School Board is still insisting our children stay masked for 3 more days until the end of the school year. They are doubling down in their opposition." Ziggy Shrugged. Thank you. I can't bring it up again. Yeah, it's. But that's the other thing. It's like, what do you do? And what do you do as a parent? I mean, this is a question I ask myself because I object, but I'm not going to ostracize my children, and I'm not going to, turn us into the neighborhood pariah where we're going to become demonized by everybody, and it's only going to be the kids that suffer. I don't mind not having friends. I mind my kids not having friends. And so, like, what do? Do you send your kids to school without a mask, have them get kicked out and make a big stink about it? Or do you begrudgingly, sit through it and hope that at the end of the day, in the long run, it levels out? I don't know the answer to that question.
Maybe just get some special edition masks. Trudeau is a crook, maybe things like that.
I've got a neighbor who's got a very unique Trudeau bumper sticker on his car that I won't be putting on mine. I still have to stay moderately respectful in my disdain for what's going on. Let's see what here. So there is less glare off Robert's face than off my forehead. Yeah, it's been hot here. Okay, it's hot in the basement, and I don't powder. I don't have a makeup person. Okay, so how many of these decisions now have we seen? Because there's one you just spoke about. I didn't read that one, but I know of it. Florida. What other states are coming out with these favorable decisions to basically say you guys have been behaving like whatever? And that's
these are the two big ones. The good Florida appellate one, and recognizing the right to privacy, includes the right to against medical Sharia law, or what I call medical Sharia law, and the Kentucky one just being another Stickman, the second case to go to trial, where once again the state loses because they can't even put basic evidence up. I mean, they can't even withstand basic cross-examination. That's the extraordinary thing about all this. Aside from the constitutional liberty deprivation that's frightening, it's the complete evidentiary lack of foundation for their claims. They're not following science. They're just following people in white lab coats pretending that they're doing science. But when they're put to trial, they can't produce the so-called science. And
it's an amazing thing. I mean, the courts in the States, you've had a few trials that have gone to evidence. In Quebec, in Canada, we've had a few ish. The Pastor Coates one out of Alberta, where there was some evidence presented. Sorry, no, it would have been more the quarantine hotels where there was evidence presented, but still on an interlocutory basis, injunctive basis, not on the merits. So we really haven't gotten to the merits of lawsuits yet. But even on the injunctive basis, the courts, if they want to be convinced by the evidence, they can convince themselves. I mean, this court convinced itself that quarantine hotels were justified based on the evidence because there was a case of one person testing positive 2 weeks after testing negative who infected their roommate who did yada, yada, yada. Even if we believe that, and I don't know how they determine all those facts, but in the Pastor Coates, I mean, with that pastor that was locked up, they've convinced themselves that there were no constitutional violations to even adjudicate on an interim basis. So it requires judges with some courage and some backbone, but it also requires the evidence to come out that, you know, it's difficult to justify what's been imposed.
Well, you got a sense of who the Kentucky judge was because he started off by quoting the Magna Carta. So that was a good indicator.
Yeah, and that is a good indicator. I mean, that has come to that where you literally have people who either respect the Constitution or you have people who defer to diktats and the ostensible immediate legitimacy of whatever the government decides to do in a state of panic, as if limiting outdoor gatherings to 10 people is going to produce results, or it's as if it's going to remedy what is the underlying problem, which might be a system exacerbated by a virus.